Can a judge consider an upward departure on the day of a SORA hearing? To find out, you have to read People versus Worley, but it's 10 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases that I try to do in 5 minutes or less. This is the episode on the case of People versus Worley. The index number for this case is 2023 New York Slip Opinion 03300, published by the New York Court of Appeals on June 15th of 2023. The issue in this case is whether every single application for an upward departure in a SORA case must be accompanied by a 10-day notice, advance notice before being considered. The lawyer has to understand to appreciate what's going on in this case, two different things. First, what due process is. Due process is a constitutional and fundamental guarantee of fairness. And basically what the cases have held is that due process requires, if you're going to hold it down to two things, boil it down to two things, it's notice and an opportunity to be heard. Notice of what's coming, notice of the attempts that the government will take to deprive you of life, liberty, or property, and an opportunity to be heard about that potential deprivation. That's the due process rights that are found in the Constitution and that are addressed by different statutory provisions of different aspects of the law. And the second thing you have to understand is what the SORA provision is. SORA is Sex Offender Registration Act. And in every single conviction for an offense that's a SORA offense in New York, there is a level, there's a hearing to adjudicate what SORA risk level the person will have. Level 1 is low risk of reoffense. Level 2 is moderate risk of reoffense. And level 3 is high risk of reoffense. And to adjudicate, there's a process to adjudicate the level of risk that a person has at this SORA hearing. And what happens is the Board of Examiners of Sex Offenders compiles 15 factors into it, which is like a checklist of a risk assessment instrument, an RAI they call it, risk assessment instrument. And they consider, for example, risk factor 1, the defendant will get 10 points. Risk factor 2, the defendant will get 15 points. And they compile it, and at the end of the day, at the end of that checklist, they add up all the numbers that have been attributed. And if it's less than 70 points, the defendant is presumptively a level 1. Between 70 and 110, presumptively a level 2. And 110 or above, presumptively a level 3. And what the statute says, this is important for this particular case, is that after the presumptive level, there's an application that either side can make for either an upward departure or a downward departure. And several of the videos that have recently been done, actually, from the Court of Appeals are about these upward and downward departure applications. And basically, the upward and downward departure application says that the presumptive level doesn't adequately capture the risk the defendant has to reoffend. And so from a level 2, it should be upwardly departed to a level 3, or from a level 3, it should be downwardly departed to a level 2. And basically, that's the arguments that can be had in front of a judge who then will adjudicate and determine what the level should be. There are time limits, though. It says in Corrections Law 168-N that if the prosecution intends on departing from the presumptive level that the board gives it, from the presumptive level based upon the points, then they have to give 10 days notice, advance notice before the hearing to the defense, before the hearing, so the defense can properly prepare to be heard on that issue. And it says, so that's the notice provision under 168N. So what are the facts in this case? The facts are in 2012, the defendant was accused of forcible sexual conduct with a child. The defendant pled guilty to attempted rape in the first degree, was sentenced to jail and post-release supervision, and he had a SORA hearing. At the SORA hearing, in advance of the SORA hearing, the Board of Examiners compiled the checklist, the risk assessment instrument, and it attributed 115 points. But importantly, just two important factors here. One is they gave the defendant 10 points for unsatisfactory conduct while incarcerated because he had 19 disciplinary infractions while in jail, 19. Another thing they did is gave the defendant 15 points for refusing or failing sex offender treatment while in jail. So when they come to court, the people explain that it really wouldn't be proper to give 15 points for that because the defendant was in protective custody. He was in like solitary confinement. And so he was not able to participate in the sex offender treatment. So it wouldn't be fair to give him 15 points for that. Now, he was given 115 points total. So if you take away the 15 points, now he's at 100 points. So it goes from a level 3 presumptively, like the board wanted or the board thought was appropriate, to a level 2 presumptively. And at that point, the judge says, well, you know what? I'm not sure that the defendant's getting maybe an upward departure is appropriate because he had 19 disciplinary infractions. That's a lot. And the defense says, well, judge, you can't just start giving away upward departures. That's for the people. They're not even asking for it. And the judge says, well, I'm deciding it. Upward departure. You have your exception. And the defendant says, well, the people aren't even asking for an upward departure. So then the judge says, well, people, do you want an upward departure? And the people, taking their cue, say, yes, judge, we have an upward departure request based upon the 19 disciplinary infractions. And the judge says, granted. Okay, it appeals, it goes to the Court of Appeals, and the Court of Appeals says this was error. Obviously, due process requires notice and an opportunity to be heard. Here, there was no advance notice before the hearing, and the defendant didn't have an opportunity to be heard. The judge basically said, I'm granting it sua sponte. And then when the defense counsel said, well, you can't do that sua sponte, they're not even asking for it. The judge said, well, what do you think, people? And the people said, we'll ask for it. So the defense didn't really have advance notice and didn't have the ability to look into this, to gather materials. They could even subpoena records or call witnesses if they wanted to. That's the point of notice and opportunity to be heard. The defense should have an opportunity to prepare a proper defense with whatever that means. And so this is rejected based upon failure to give sufficient due process to the defense. And it's a reminder that in SORA cases, no less than any other kind of case, due process is important and required, and the practitioners in this area have to comply with the time limits found in 168-N. That's the case of People versus Worley. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.